Hi, I'm Shaye Larkin and thank you for visiting. If you've watched my other videos, you know that I'm a bankruptcy attorney here in San Francisco. In this video, we're going to talk about the bankruptcy trustee, who they are, and what is their role. There is a trustee in every bankruptcy case filed, and their role is different depending on the chapter of bankruptcy. In this video, we're just going to talk about Chapter 7 and Chapter 13 because those are the two types of bankruptcy cases that I file. We'll start out talking about the Chapter 7 trustee, and where their role differs from the Chapter 13 trustee, I will mention that. So the Chapter 7 trustee's duties are laid out in Section 704 of the Bankruptcy Code. There's many, it goes on for a couple of pages, but I will just list some of those duties here. First, the trustee collects and reduces to money assets of the bankruptcy estate. The bankruptcy estate is what comprises all of your assets when you file bankruptcy. Everything goes into this invisible bankruptcy estate, and the trustee is in charge of administering the estate. So that doesn't necessarily mean that you don't own these assets anymore. You still own them. It's just that you don't have control over them. The trustee has control over them during the pendency of your bankruptcy case. You can still sell an asset, but you have to get permission from the trustee. And yes, you can spend money that's in your bank account while your bankruptcy is pending, but just know if there's a problem about it later, you may have to pay it back. So it's good to keep things very simple as your case progresses through the system until you know it's okay to make changes. Your bankruptcy attorney can advise you about how to proceed once your case is filed. So getting back to the trustee's role, liquidating assets of the bankruptcy estate, that only applies to assets that are either totally not exempt or partially not exempt. And it's kind of sad, but the trustee can actually liquidate an asset that's partially not exempt, and I will give you an example of that. So you own a house with 4 other family members. The house is worth $800,000. You each own 25%. You live in the house with a family member, so you are entitled to a $100,000 exemption against the equity of the house. This is talking as if you filed in California and you're a California debtor. Sorry, that's an unfortunate term that we use in bankruptcy, debtor. I know it's not flattering, but that's what we call people who file bankruptcy. So you live in California, so you get to use California exemptions, which provide for a $100,000 exemption on the equity in your home, assuming you live there with a family member. So this house is worth $800,000. You live there with your family member. You're using your $100,000 exemption, but you own 25%, and your 25% share of that house is actually worth $200,000. So that means your house, your interest is partially not exempt. And in that situation, the trustee can sell the whole house, but they have to give your relatives their share of the proceeds. You get your exemption amount, and the rest would go to your unsecured creditors. And if you don't want that to happen, then you would not want to file Chapter 7. You might explore Chapter 13 instead and see if that's an option, or opt to not file bankruptcy. That's also an option. So that's one of the roles of the trustee, is liquidating assets. And then as part of that, they have to be accountable for all property received. So that means providing an accounting, a public accounting that everyone can see. You can log into pacer.gov online and see the trustee's accounting. Their role is also to ensure that the debtor has performed their intentions with regard to secured assets. So secured assets are things like cars that are subject to a car loan, houses, and when you go to your bankruptcy hearing, which I'm going to talk about in another video, the trustee will ask you in a Chapter 7 if you have performed your intentions with regard to either your house or your secured auto. And what they mean is, have you been continuing to make the payments if that's what you want to do? Or have you surrendered the item if that's what you want to do? So that's something they look into in a Chapter 7, and that's one of their roles. They also investigate the financial affairs of the debtor. Again, that unflattering term, but oh well. As part of that investigation, they schedule a meeting of creditors, and how that meeting of creditors takes place is different for every jurisdiction, but there are some things that every jurisdiction does the same. They call you up to the front of the room at this meeting of creditors. No, most of the time your creditors are not there in the room with you. You're going to be there with your attorney, or if you're filing without an attorney, which I don't recommend, then you get called up to the front of the room by yourself. Now, regarding creditors showing up or not showing up, it is called the meeting of creditors because the creditors have a right to show up, but as a practical matter, they almost never do. The types of creditors who do often show up are ex-spouses and ex-business partners because they're angry, and sometimes landlords too. So at the meeting of creditors, you are asked questions about your financial situation under oath in front of a tape recorder. If you need a translator, the one will be provided for you. They use this telephonic translator that they call right there at their desk, and they're approved by the court. So the first thing they do after calling you and your attorney up to the room is they put you under oath, and they examine your proof of your social security number and your photo ID, and there are certain acceptable things that you could prove your social security number and photo ID with. As for social security number, it has to either be the original social security card, or it can be a W-2 for your from your employer for the most recent tax year. It could be a 1099 from someone you worked for in the most recent tax year. It can be an insurance card if it happens to have your social security number on it. Most insurance cards don't these days, so make sure that whatever you want to use, it has the correct full social security number on it and your name, and it must be the original document. You can't bring a photocopy of your social security card. And as for photo ID, you can bring a California ID or whatever state you live in, that state's ID. You could bring your passport, that works too, but make sure that these items are not expired, because then you're not even going to get through the front door. Many of these places where the meeting of creditors are held are in the same buildings where there are federal offices, and you have to go through security, and they check your ID at the door, and if you don't have it or if it's expired, then you don't get to have your hearing that day. You have to come back, and that's something that I want to mention. If you're probably wondering, do I get to pick the day of my hearing? No, that's actually assigned on the day that your bankruptcy is filed. If it's a Chapter 7, when I file a case, at the end of filing all the required documents, I click on this button that says Judge Trustee Assignment, and then that generates the trustee. I don't have control over who the trustee is, and it also generates the meeting of creditors date. And in a Chapter 13, you don't normally get the hearing date right away. They send it to you about 2 weeks later. So if you're not available on that day, we can write to the trustee and say, we need it to be rescheduled. Some trustees are more workable than others, and some will say, okay, I'll call your case, and when you don't show up, we'll just reschedule it that day. And that's great. Then you don't have to renotice the entire bankruptcy. But other trustees will say, no, you need to send out formal notice to all of your creditors that the hearing is being continued, and that's okay if they do that. It's not that big of a deal. If you continue your meeting of creditors, that will continue all the deadlines in your case, and it will take a little longer to get through the system. And usually you don't have any control over the rescheduled date. So if you can, try to get to the first date, because the second one might be even worse. And if you don't make the second one, the rescheduled date, then that's bad, and your case will be up for dismissal if that happens. And then again, as part of the investigation, they ask you questions about your bankruptcy. They might say something like, what's the address of your current employer? How long have you worked there? They might ask you about any real estate that you've owned in the past 4 years and what happened to that real estate. They might ask you if you're expecting an inheritance, because there's a special rule about inheritances. Generally, property of the bankruptcy estate only includes what you own as of the day your bankruptcy is filed, but there's a special rule with regard to inheritances. Inheritances that if you become entitled to an inheritance, whether it be money or property or life insurance proceeds, within 6 months of the day your bankruptcy is filed, then that is actually property of the estate. Even if your case by that point is discharged and closed, you actually have a duty to contact the trustee in your case and let them know that you became entitled to an inheritance, and then they can administer it for the benefit of your creditors to the extent that it's not exempt. So, but if someone passes away 6 months and 1 day after your bankruptcy case is filed, then they're outside that rule. All right, so that's one thing that virtually every Chapter 7 trustee asks about at the bankruptcy hearing is, has anyone died recently that might leave you money or property? They ask if you rearranged your financial affairs before filing bankruptcy. That means things like you quit a job, and what they're looking for in that sort of question is they're looking to see if you purposely changed your income or expenses in order to qualify for Chapter 7. So that's what they're aiming for there. They ask for, are you still living at the same address? Did you review the bankruptcy paperwork before it was signed? Is it accurate, true, and correct? Has anything changed in your financial situation since you filed bankruptcy? That one is always asked. Those probably the questions that I'm talking about today are asked by every trustee unless they happen to forget, because sometimes they get distracted and they might forget to ask a question that they would otherwise normally ask. But these ones that I've already mentioned are asked in virtually every bankruptcy case. So has your financial situation changed since you filed for bankruptcy? What they're getting at there is, in a Chapter 7, has your income gone up such that maybe you don't belong in Chapter 7 anymore? And in a Chapter 13, that question, it means has your income gone down such that you can no longer afford the planned payment that you're proposing? Or has your income gone up such that you should be paying more to your creditors? So that always gets asked, and many times people file bankruptcy when they're unemployed. That's really kind of the ideal time to file a Chapter 7. And maybe by the time you have your hearing, you found a job. So they're aware of that possibility, and they are aware that you are unemployed at the time you file because they have a copy of your bankruptcy and they know what you said in it, and they're going to ask if you're still unemployed. I didn't mention this, but Chapter 7 here, meeting of creditors are held between 30 and 45 days after the bankruptcy case is filed. And I did say that you'll know that hearing date when the case is filed. In most jurisdictions, there are a few where you find out like the next day. And Chapter 13 cases, usually you find them out like 2 weeks later. There might be little things they noticed in your bankruptcy. I've had trustees ask about storage units and safe deposit boxes, like when was the last time you went into your safe deposit box? They might ask for more documents at that meeting of creditors. That's another thing that they do before the bankruptcy case has its hearing, is they ask for documents. And they usually do that within 2 weeks of you filing bankruptcy. They ask for copies of tax returns, bank statements. Usually they ask for the month of filing, but sometimes they ask for more, especially if you're self-employed. They might ask for a year's worth of bank statements. I've had trustees ask for 2 years worth of bank statements, so that's something to be aware of. They ask for documents showing how we valued the car and the house. Like, they want to see a broker's opinion for the value that we came up with for the house. They might ask for real estate documents like deeds of trust. They always ask for pay stubs. We used to file pay stubs with the court. That's, the part of your paycheck that shows what the deductions were. We used to file them with the court, and then at some point the court said, wait a minute, these are confidential. So now we always just give them to the trustee. So the trustee will have received all of these, hopefully, before your case is filed. If you have an attorney, make sure you get these items to the attorney, because the trustee can actually have your case dismissed if you don't provide the requested and required documents at least 7 days before your meeting of creditors. So I probably should have mentioned that early on, because it happens before the meeting of creditors, but better late than never. So the trustee will have reviewed your bank statements before your meeting of creditors, and they might have questions about big transactions, like, what is this deposit here from, and who is this person that you gave a check for $3,000 to? We're going to talk about things like preferences in bankruptcy in another video, but they're looking out for preferential transfers to family members in particular, because they can actually get those back. So that's pretty much it. I mean, I can't predict what the trustee will ask in your case. Every case is different. Last month I had a trustee who, prior to the meeting of creditors, she looked at my client's bank statements and saw that he made some money selling a pair of shoes twice. So then she got this idea in her head that my client was in the business of buying and selling shoes, and asked him about it at his hearing, and we allayed her concerns by emphasizing that this was done because he needed the money, and he's not in the business of buying and selling shoes. He happened to have a couple of pair of Air Jordans that were in brand new condition, which he sold, and those are the only shoes that he has that are worth selling. So things like that come up. Some trustees are more aggressive than others. If they're satisfied that they got all the information that they need in your meeting of creditors, then they will conclude it. And in a Chapter 7, if they conclude the meeting of creditors, you are normally entitled to discharge if once 60 days from that day have passed. So on the 61st day, you would become entitled to discharge. Of course, that could change. Problems can come up. If it's an asset case, things can get dragged out. The trustee, I don't want to get too far afield here, but the trustee will normally, in a no asset case, they'll normally file a no asset report shortly after the meeting of creditors, and then the case proceeds to discharge. In an asset case, they don't file a no asset report, and things can take longer. And then in my jurisdiction, if it's a no asset case and the trustee has filed her no asset report, then usually about 63 or 64 days after the meeting of creditors, we can expect the discharge to be entered, and the court will email it to me in my court email, and then I can forward it to my client. Can the trustee continue to investigate you after the meeting of creditors? Absolutely. If you suddenly get a new job during the pendency of your bankruptcy case, what can the trustee do? Well, they can require you to file a new budget with the court so they could see what the difference is between your income versus expenses. And if they see a surplus there, they can file a motion to dismiss unless you convert to Chapter 13. So that's sometimes an issue. That's been an issue in some of my cases, and in many of the situations it happened because my client got a new job, which is a good thing, of course. And usually when you're unemployed and you prepare your bankruptcy budget, it's going to be a smaller budget because you just don't have as much money. But once you get a job, then you can afford to pay what you should be spending on food and utilities and your cell phone bill and other things. So oftentimes you're able to file an amended budget that shows that your new income is completely swallowed up by expenses that were not included previously. And if that happens, then staying in Chapter 7 should not be a problem. So let's talk a little bit about Chapter 13, because the Chapter 13 trustee's role is different than the Chapter 7's in a few ways. So they have the meeting of creditors, just like the Chapter 7 trustee, and they require usually more documents than the Chapter 7 trustee asks for, simply because you're going to be in bankruptcy usually for 3 to 5 years, and they want to really make sure that this is something you can do. They don't like seeing people file Chapter 13 only to have their case dismissed. So before they'll even approve the case for confirmation, that's what the judge's stamp of approval is called, they will investigate it. And some Chapter 13 trustees are more thorough than others. So they ask for the documents, just like the Chapter 7 trustee, and then you have your meeting of creditors, and at the meeting of creditors, they're going to tell you, this is what you're proposing to pay through the Chapter 13 plan. Can you afford to pay that? And then they ask about your income. Has it changed? They might have noticed that you got a bonus, 6 months ago, and they want to make sure that you included that in your budget. Sometimes bonuses are a one-time only thing, and other times they happen pretty regularly, and they're aware of that. They want to know if you filed your tax returns, all required tax returns for the previous 5 tax years. And the reason for that question is because if you've not filed your tax returns, you might actually owe the IRS or the state taxing board money, which should be paid through the Chapter 13 plans. And if you haven't filed those returns, then that money that's owed potentially is being left out of your bankruptcy. So they ask about that, and they can actually seek dismissal of your case if you've not required all required tax returns by the time you have your meeting of creditors. So that's something to be mindful of, especially if you're filing without an attorney. And I never recommend filing bankruptcy without an attorney, especially not Chapter 13. I know in my jurisdiction, the Chapter 13 trustee, I haven't heard him say this lately, but he used to say, no one has ever filed a Chapter 13 successfully in this jurisdiction without an attorney. And the only reason I haven't heard him say it lately is probably because he's had his staff attorneys handle the meeting of creditors. But when I have had him, he says that in the meeting of creditors, that he advises you, for the sake of your case, to get an attorney if you don't have an attorney, because chances are that your case is not going to make it. So back to the meeting of creditors, they're going to say if they have problems. They might have already told you in advance about problems that they have with your plan. They might think you can actually pay more. They might think your budget is a little too fluffy and you need to cut back on a few things. They might want you to file some amendments. They might want an amended plan. Usually they tell you that in advance, but not always. Sometimes they don't have time to give a good thorough look at your bankruptcy before the meeting of creditors because they're very busy. And so they spend some time looking through things while you're sitting in front of them. Chapter 13 hearings are longer than Chapter 7 hearings, as you might imagine. Chapter 7 hearings, once they call your name, it's like 2 minutes later you're out, unless you happen to be part of a corporation, like a CEO of a corporation, then you're going to be sitting there for 45 minutes, and everyone else in the room has to sit there for 45 minutes waiting for your case to be concluded. But generally, Chapter 7, you're in and out once they call your name in like 2 minutes or less. Chapter 13, it's like 15 minutes being there in front of the tape recorder and the trustee with your attorney. So they're going to say if they have problems with the plan. They're also probably going to say if they are inclined to recommend the case for confirmation. And again, confirmation is the stamp of approval, and it's the judge that ultimately issues the order on confirmation. Now, if everything goes well, you never actually see a judge in a Chapter 7 case. It's only the Chapter 7 trustee. In a Chapter 13 case, it really depends on the issues, and it depends on the jurisdiction, because in some jurisdictions you have to go to the confirmation hearing, and at that hearing you would see the judge. In my jurisdiction, if there aren't any problems, if the case is going to be confirmed, there's no reason for you to show up. But maybe you might be doing some litigation in a Chapter 13, in which case you would see the judge. In a Chapter 7 case, again, if there's litigation, you're going to see the judge. If there's a motion to dismiss your case, you're going to see the judge, most likely, unless it's withdrawn. So once the Chapter 13 meeting of creditors is concluded, then they usually put the case on the pending list, and the pending list basically says we're going to give it another look. If we see anything else, we'll let you know. For now, it's on the pending list. And then at some point they take it off the pending list and put it on the confirmation list after you've done everything they've asked for, and then it goes through the system. The trustee in a Chapter 13 case pays the creditors, so they examine the proofs of claims. And in a Chapter 7, if it's an asset case, then there are also proofs of claims. That's how creditors are paid. So you cannot get paid out of either a Chapter 7 asset case or a Chapter 13 case unless you file a proof of claim, and you have to file it before the deadline. And the trustee will object if a proof of claim is filed after the deadline. And they also examine proofs of claims for appropriateness, and that's also your attorney's role too, to look at every proof of claim and make sure that they're not asking for something that's illegal or not appropriate. So that happens after the meeting of creditors, all these, and sometimes before. Sometimes the creditors file their proof of claims right away. They have a certain period of time to do that. We'll get into that in another video. And the trustee examines them. If they are okay with the proof of claim, then they get paid whatever they're supposed to be paid pursuant to the plan that's ultimately approved by the court. So they're going to stay involved throughout the remainder of your Chapter 13 case. And they get a fee. The fee can go up to 10% of the total amount to be paid through the Chapter 13 plan to creditors. So if you're paying $50,000 back to your creditors over the course of 5 years, the trustee's fee would be $5,000, and they're able to collect that. That's calculated at 10%. It can be lower than that. Right now, I think in San Francisco, it's 8%, but because it can bounce up and down, we don't want your case to be dismissed for not paying the appropriate amount to the trustee, so we calculate it at 10% to give you a cushion, and then sometimes you get a refund check at the end of the Chapter 13. If you want to sell real estate during the pendency of the Chapter 13, then even though assets revert back to you upon confirmation, you still need to work with the trustee, and usually you need to file a motion to accomplish that. But some things are different in other jurisdictions, so it really depends on what the rules are where you are filing bankruptcy. And always talk to an attorney. So I think this video has gone on a lot longer than I thought it would. I hope that I've been articulate and maybe not concise, but hopefully articulate, and hopefully everything was understandable. In my next video, I'm going to talk about what to expect from your meeting of creditors. It's going to be a short video because I basically went over all of that in this video. And then there's going to be other videos. I want to, at some point, talk about virtually every aspect of a Chapter 7 and Chapter 13 bankruptcy case. So thanks for watching, and have a good day.